Operations Excellence webinar series, which is a new series sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman-Lundberg-Wisner firm, which aims to provide insightful and useful information to the IP community. For this particular webinar series, we have pulled together patent operations experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key operations challenges and issues and share best practices. The Operations Excellence webinar series is free. This is the first of about 8 webinars in this series. There'll be one a month. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover best practices and processes for managing Invention Disclosure and Inventor Awards programs. We've allowed time for questions at the end of the program. Questions may be submitted using the question button on the right-hand side of your browser window. The questions will be held in a queue until the end of the presentation. Before we begin, I want to let people know that Black Hills IP is presenting a free full-day docketing seminar in Washington, D.C. on November 8th. The content of the seminar is different than the content of the docketing webinars that we've been putting on. So if you've listened to many or all of our docketing webinars, the seminar will not be a repeat of those. The seminar is an interactive workshop with something to offer even for experienced docketers. To register for the seminar in DC, again, go to the Educational Resources tab on the Black Hills IP website, then click on Seminars under the Docketing Excellence heading. The presenters today are myself, Angela Smith, Mary O'Malley, Michelle Rickliff, and Jennifer Bementry. And as panelists, the 4, Angela, Mary, Michelle, and Jennifer will be speaking in that order as we go through the program. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Angela, can you tell us what your background is?
Yes, thanks, Ann. So as Ann mentioned, I'm the senior manager of patent operations at the Boeing Company. I started out as a paralegal in a patent IP law firm. Was a paralegal for about 12 years and then came to Boeing. I entered Boeing in the law department and then went out into the business to learn the business side and negotiated contracts for about 7 years, and then came back over to the patent group where I have the opportunity to manage a staff of about 15 people and work on the patent portfolio.
Great, thanks, Angela. Mary, tell us about your background.
Thanks, Ann. I'm the patent program manager at eBay. I've been at eBay for about 12.5 years. Prior to joining eBay, I worked at both law firms and corporations. I have about 25 years total experience as a paralegal and a program manager. I also taught patent prosecution classes in the paralegal programs at both Santa Clara University and West Valley College.
Thanks, Mary. Michelle, tell us about your background.
Hi, thank you, Ann. I have been in the IP world for about 20 years. The first 3 years I was at a small firm, Vitus Ehrenstein Krause, and moved to Boston Scientific and have been here for 17 years as a paralegal.
Great, thank you. And Jennifer?
Good afternoon. I am a foreign filing paralegal for Schwegman, Lundberg, and Wisner. I've been here for 9 years now, going on 10 years. Before I came to SLW, I was an in-house paralegal for Graco, Inc. And And prior to that, I was at another intellectual property law firm here in Minneapolis, Merchant & Gould.
So, Jennifer, as you speak today, I've asked you to speak from the perspective of Graco, which is a smaller company compared to Boeing, eBay, and Boston Scientific, to give us that perspective. So thank you very much, all four of you, for agreeing to participate today. As we go through the program, I'll have the panelists speak in the order that we just introduced them in. So it will be Angela, and then Mary, and then Michelle, and then Jennifer. The topics for today's program are invention disclosure programs and also Inventor Awards programs. Those often go hand in hand. These programs tend to vary from company to company. As a result, the processes involved are typically very company specific. This particular webinar series is focused on patent operations. So we'll be talking about the process aspects of implementing an invention disclosure submission program and an Inventor Awards program. Some of the things that we'll discuss will be things like software or systems that are used to manage your programs, how those systems are used, who runs those systems. I'm looking forward to hearing how these programs are implemented in each of your companies. There's a poll on the screen that I would like everybody to respond to if you haven't. First, I want to find out what portion of our audience is from a corporate background versus from a law firm, and then there'll be a second poll after that that has some questions about how many invention disclosures you typically receive per year in your organization. So I want to start by asking our attendees, or our panelists, how many invention disclosures your organization receives per year. Do you get 100 or less, 100 to 500 per year, or more than 500? And we'll start with Angela.
Thanks, Ann. So yes, the Boeing company definitely gets more than 500 per year.
Okay.
And eBay would fall into that category as well.
Okay.
Boston Scientific as well.
All right.
Well, when I was in-house at Graco, we probably would receive about 100 disclosures per year, in between 70 to 100.
Okay. So I'm looking at the results here on the screen, and let me first see if I can go to the first question. So 69% of our audience is from, works in a company, 20% in a law firm, and 12% are listed as other. Then the audience makeup is a little bit different than our panel. 54% of the audience has 100 or fewer disclosures a year. 16% are in the 100 to 500 category, and only 7% have 500 or more. And then again, about 20% of the audience doesn't work in a corporation, so they don't have disclosures. So that's interesting because many times these smaller organizations have programs that start small, but they're growing. And even though you may be in the 100 or less category right now, as your program grows and your company grows, you will likely trend more towards the higher category. And so I think this is really great because as you hear the insights that Angela, Mary, and Michelle are going to share with you, that may help you as you plan for growth in your own organization. So I think this is going to go really well. All right. Trying to get control back on my screen. There we go. So to start off with managing invention disclosure programs, there are a couple different approaches that you can use for collecting invention disclosures. One of them I would call the push approach, which means that inventors are voluntarily submitting disclosures and pushing them to the IP department. The other approach would be the pull approach, and that means that the IP department is actively seeking out or soliciting disclosures from the inventors and pulling them into the IP department. So again, we'll start with Angela and go through the panel. Can each of you explain what you do in your organization to collect disclosures?
Thank you, Ann. So we definitely use both aspects in collecting disclosures, a push and a pull. We use Memotech in order to gather our disclosures in one place. So whether the inventors are pushing them to us in Memotech by filling out an invention disclosure form, or whether our team is going out to collect those disclosure forms and then putting them into our system, we do it both ways. We do use the brainstorming and approach. We, in fact, will go in sometimes if we have a situation where, since we sell airplanes, that maybe an airplane could be grounded for something by the FAA, and we have to go in and find a solution quickly over a weekend. We will actually send in a technical team, to go solve that issue, as well as our patent group will be there alongside of them, making sure that we are capturing the disclosures in real time in order to get that provisional application on file before a press release goes live on Monday morning. So that's how we handle it. We do a lot of different things, a lot of different harvesting methods to capture them. So we definitely do both methods.
Great, thanks, Angela. Mary?
We are very similar to Boeing. We do both push and pull. So we have a patent portal which sits on our internal hub that's accessible to all of our employees globally. It's sort of a one-stop shop where they can submit their ideas, check the status of their ideas, get explanations on what a good idea is, in case they need some guidance. And we also do, I would say 50% of our ideas come in through this portal, and the remaining 50% come in through outreach. And our patent attorneys do a significant amount of outreach, things like patent 101 training, where they meet with new inventors, train them in patent protocols, brainstorming sessions, such as Angela mentioned, around specific new technologies or product, attendance at new hire trainings, things like that. And I'd like to add one interesting thing that we've added into this system. We have added the ability for our employees globally to submit their ideas in their language that they're comfortable with. So for example, our inventors in Korea can go to our portal. They can select Korean as their language of choice, and they will see our portal in Korean, and they can submit their ideas in Korean, and then it's translated into English. So that has helped us generate a lot of idea disclosures in our different countries.
Wow, that's pretty cool that they can do it in their own language. That's quite the tool, Mary. Michelle, how do you collect disclosures at BSC?
Actually, we're not too different than the previous two. We do a lot of push and pull. As far as the pushing, the inventors can go ahead and enter it into Foundation IP, which is the system we use in the disclosure module. They can do it individually or as groups. And we do pull. We use the brainstorming quite a bit, actually, for various reasons, like new projects that are coming up to get the juices flowing. If we see that disclosure submission numbers are down in any of the technology areas, we try to get those inventors a little bit more involved. So we try to set up some brainstorming, as well as if we've got newcomers in engineering R&D, we try to get them involved as soon as we can by using the brainstorming as well.
Okay. And Jennifer, what did Graco do?
The engineers at Graco would submit the invention disclosures via paper through interoffice mail, although I've since learned now that they have instituted electronic submission of their invention disclosures, and Graco has Lotus Notes, so they would be submitted through Lotus Notes to the Intellectual Property Department, and as the paralegal there, we would be responsible for the intake of that disclosure and managing the process after that. most oftentimes, I'd say 90% of the time, it would be a push into the intellectual property department at Graco. However, there were instances where we had product release of a particular paint gun or a system for one of the business divisions they were releasing product, and we would have to meet with the engineering department and find out and make sure we had coverage of that of that particular product before the product release.
Okay, good. So there's been a couple systems mentioned as the panelists just talked through the first question. I heard Memotech, Foundation IP, Lotus Notes, internal portal. So I have one more poll for the audience, and that is, what software do you use to manage invention disclosure submissions? You can take a minute and respond to that poll. And then I'm going to, while the audience is responding to the poll, go back to the panelists and ask our panelists to talk about the systems that they use, how they use those software systems, and who runs and manages those software systems. So Angela, can you get us started?
Of course. So definitely we use Memotech. Memotech is housed internally on an intranet where folks only in the United States can access that system. So our inventors can go in and put in the information directly in real time. Our team does manage that software in connection with our art and IT focal. However, we do have a different process for outside the U.S. Since we have a lot of export issues, since we do government contracts as well, we are not allowed to give folks outside of the U.S. access to that. So they will have a system similar to what Jennifer mentioned at Graco, where it'll come in by internal mail, and then we'll take that and we'll go ahead and load that in ourselves. So the system is run by us, but we do have kind of a mixed approach for our different divisions.
Okay. Mary.
So our system is the same globally. We don't have the export issues that Boeing has, but we use Foundation IP as our docketing system, and Foundation IP does have a disclosure module, but we found that we couldn't easily customize it. You know, we have very, very specific flows. So as mentioned, we built our own tool where employees can go and submit their ideas, and then those ideas are pushed into Foundation IP in real time to begin the review process by the patent team and also our patent committees. We also have the ability to, upon review of an idea, push it back to the inventors, asking if they can please, provide more specific information. The inventors can go into this portal and they can collaborate, they can edit their idea, they can provide new attachments and resubmit it under the same disclosure number to begin the review process for all of our ideas. All of the patent tools and databases are managed by the paralegals on our team, of which there are 2. So we try and automate these systems as much as we can. They have automated responses built in when an idea is submitted, when it's been approved. There's a lot of automation in our flow. And because it's a tool built within eBay, we also have a dedicated IT team and the Foundation IP Web Services team that we work very closely with.
That's quite the system, actually, Mary, but that sounds like that's a pretty awesome system that you've got. Michelle, how about BSC's system? What are you using? How do you use it, and who runs it?
I can pretty much say ditto to what Mary just said. We also use Foundation IP, so we've got the highly automated pushing system from the inventors to the paralegals at our various sites manage the divisions and technologies. So we are pretty automated as far as the divisions go, to work with our own inventors. Our IT actually is in India, so we don't use our internal IT much with Foundation IP. We count heavily on the vendor for that. And the paralegals really manage everything from intake to the review boards and to the outside firms. So.
Okay. Jennifer, how did it work at Graco?
So for Graco, the disclosures would come in via interoffice mail. As the IP paralegal, I would handle the intake of those disclosures, assign file numbers, and then there would be quarterly reviews with the business units, the 4 business units that are within Graco, to make a determination about whether or not to move forward with that particular invention disclosure. But most of the system would have been paper-based, and the person managing it would have been me. And I know now that they have a database that they created themselves internally, that Graco created internally with their the IP department in connection with their IT support to track their disclosures now, including, filing dates of applications and things like that. And it's Lotus Notes based, so that's the update to Graco's system.
Okay. Did any of you or do any of you have systems where you have like an electronic meeting room or something? And I'm jumping a little bit ahead because the next slide we're going to get into the process for evaluating disclosures and selecting ones to move forward for filing. But while we're just talking specifically about the systems, do any of the systems that you use have a electronic type meeting room where you can hold those meetings or comment and review disclosures or collaborate together on them?
I can speak for eBay. I mean, we have internal tools that we use where we can do exactly that type of collaboration, but nothing specific to our patent database.
Okay. Angela, does Memotech have anything like that?
Memotech does not have anything like that. We use a similar in-house product for collaboration as well.
Okay. Then how about communicating with the inventors? How is the process of communicating with the inventors handled? I'll let, we'll go in the same order. Angela, I'll let you start off, and then we'll go to Mary, Michelle, and then Jennifer.
Okay, perfect. So we do a lot of push communications out of our system. We have a lot of auto-generated emails for different points in time to make sure we are communicating with our inventors often, and there are no questions, so they always know where they are in the process. We do make sure, though, every inventor, after we review a disclosure and make a decision on whether or not we're going to file it or not, we do make that phone call to every inventor just to make sure that we're making that personal connection as well. So we do have those methods as well, plus some group mailboxes that we also use to communicate with those teams. So kind of a mixed bag, Anne.
Okay. Mary?
I would echo everything that Angela just said, with the addition of if there are, if it's gone back and forth electronically and there's still some, they need additional information or, something just isn't quite gelling, our internal eBay attorneys will reach out and with a phone call or a personal meeting and, talk about the idea in more detail. But other than that, it's almost all done through push-pull in the database.
Okay. Michelle?
Yep, I'm going to say ditto again. For the most part, we have some automated emails to go out to let the inventors know that their submission has been received. And then, further through the process, we will personally email them if more information is needed or to let them know what the outcome is of the review. Yeah, I guess that's it.
Okay. Jennifer.
Most of the time we'd communicate with our engineers via email, although I was in a position to be able to actually run around our building at Graco and go and talk to a number of them if required, but most often through email.
Okay. All right, well, before we go on to the next slide, I want to give the results of the poll. So in response to the question, what software do you use? 17% of our audience uses Memotech or FIP, so they're on the same systems that our panel is talking about. 27% say other commercial software not listed, and unfortunately our tool here for polls limits the number of choices I can give. I would have broken these out if I could give more options, but I wasn't able to. So a couple of the other commercial software systems that I can think of that have disclosure modules in them are Anaqua and AppCall, and there's probably others. So a third of the audience is in some other commercial system that has a disclosure module. Only 9% of the audience has developed an internal tool, and about half the audience, 47%, doesn't have any software that's specific for this purpose. So moving on, let's now talk about the evaluation and selection process. We've talked a lot about how to collect disclosures and manage them and what software we use, but now how do you evaluate and select disclosures? I have on the slide that you're looking at what I would call a typical process. I'll go through that real quick and then I'll let our panel talk about how they do it. From my experience, a pretty typical process is to somehow obtain or harvest those disclosures like our panel has talked about. Then there's generally some pre-screening. Sometimes, as also our panel has talked about, those disclosures need to be sent back to the inventors for some additional information. Typically, there's a step where there is some searching of prior art that's done. Some companies have a committee that reviews and makes the selection. And then after a selection has been made, there's obviously some kind of a process to assign that to an attorney, whether that's an in-house attorney or outside counsel, to get that set up in a docketing system and tracked. And then generally there's also some budgeting that goes along with these in the corporate environment. So that is what I would call just a representative process. But Angela, can you start us off with the process at the Boeing Company?
Of course, Ann. So our process is very similar to what you just kind of walked through. There are some nuances, of course. So our team is housed outside of the law department. So it is a little different of how we do some of our interactions. So we roll up underneath the CTO. Why is that important? It's important because when I use terms of how we look at things and some of the things that we do when we review the disclosures, they're not always handled by when I'm using paralegals or attorneys. Okay, so I think that's important for the audience to understand. So what we do is the disclosure comes in and it is looked at by an initial someone that's in the technical specialty of that group. That's your pre-screen function. And then from there, it goes on to a patent portfolio manager, which is someone that specializes over a certain area of technology. So they're in charge of, say, manufacturing or environmental. Those are two of our buckets. And those individuals will look at their technology area and they will make the decision, do we want to go forward with this? If they do want to go forward and file an application on that invention, then they will take it, assign it to a patent prosecution professional, and that patent prosecution professional then will start working with outside counsel in order to get applications prepared. In some areas, we do have some patent committees set up. They are specific to business units, though, but that is not part of our everyday process. Regarding budgeting and tracking, we do use a system outside of Memotech. Passport is the system that we've chosen to use for using our budgeting and keeping everything on track. So that's our process.
Great. Mary, how does the process flow work at eBay?
So at eBay, once a disclosure comes in, it is pre-screened by the legal department, by the patent team, and that would include, just making sure that there's enough actual information in the disclosure to, pass it into the next steps. And also, it's assigned a technology category. Once it's, assuming it doesn't have to go back to the inventor for additional information, it's assigned a technology category. There is a quick and dirty patent search done, prior art search done, and it is put into the queue for the patent committee review. And our patent committees include technology experts within the company, it's based on their technology specialties. They go to the committee for review. The committee can either, say, yes, this is a great idea, let's file, or send it back to the inventor for additional information. Or sometimes we even invite the inventor to come to the next patent committee meeting to sort of state their case and answer additional questions. Post-committee review, depending on the outcome, if it's closed, it goes into an automated process that goes back to the inventor telling them why it was closed. If it's approved, it would go to outside counsel, who would then do a more in-depth search and draft a single claim and come back to us and say, hey, we haven't found anything, here's our proposed claim, and we would take it from there. We have a pretty extensive docketing system to manage the time frame. We do try and file patents or applications that are approved within 3 months of receipt. So we have a pretty extensive timeline within our docketing system that the paralegals manage. Has it gone to the committee? Has it been reviewed? Has it been authorized for filing? Has it gone to outside counsel? Has outside counsel given us their proposal? It's a pretty regimented procedure, and paralegals are responsible for docketing all follow-ups and due dates. Budget tracking, our budgets are set at the beginning of the year, so and they are all tracked through time metrics, and Foundation IP pushes each disclosure into time metrics so that we can track budgets against each individual disclosure. So that is our system.
Well, Mary, I just want to comment, it's quite impressive that you are getting things from submission of a disclosure through being filed at the USPTO in a 3-month window. Not only is your evaluation and selection process happening, but also then the actual drafting process with your outside counsel and filing. That's quite impressive. You have a very fine-tuned process, I'd say, to do that.
I'd give you the caveat that is a fairly recent process, and it's only in the last year that we've been able to sort of perfect that. So it takes a while to get to that point.
Kudos to your patent team. That's quite impressive. Michelle, how's the process work at BSC?
Upon submission of the invention disclosure, we've got the backside of the disclosure module customized a bit because we have different legal departments in different parts of the country that deal with different technologies. So when it's pushed through, it comes to the different paralegals that are managing those technology areas. Once the paralegal receives it, we set up a prep for the patent review board. The patent review board actually consists of people in legal, R&D, marketing. It's a big group just so we can get the voice of the customer and the voice of the business to help us get toward a better disposition of this. Once we go to the prep board, just a smaller group meets to take a look at whether or not there could possibly be prior art. The attorneys know pretty well, or they've already worked with the searchers, the internal searchers, to pull any prior art to help make a better decision. If there is and they decide to nix it, we nix it right there. If not, we take it to the Patent Review Board, consisting of all of those members, and it's reviewed. Sometimes the inventors present their idea to the board. The discussion is had during the board, the disposition is made. If the decision is to close the invention disclosure, we let the inventors know with a personal email just saying thank you and, you know, keep trying. If it goes through for filing, we send it to the outside firm after it's assigned to an attorney, and then the paralegals track it from there to filing. As far as budgeting, we also have fixed fees that are decided at the beginning of every year, and that's we invoice through CouncilLink, and that's our tracking system.
Okay, good. Jennifer.
So our our information or invention disclosures would come in via paper through interoffice mail. As the IP paralegal, I would log them all in, assign them with a file number, and then it would be discussed, those patent disclosures would be discussed quarterly at each division meeting with the division lead, and the engineering lead would also be in those meetings, as well as our IP attorney for Graco. And a determination would be made then whether or not that application would be drafted and filed. So it would be a quarterly review of the outstanding disclosures, and a decision would be made at that point in time. After the decision was made and it was assigned to be a drafted application, my IP counsel would draft the application and then we would file it. There wasn't really a system set up internally at Graco to record or track the disclosures and the time frame from when the disclosure was submitted to the department, the internal IP department, versus when that application actually was filed. The only mechanism we had was the quarterly patent review meetings with the 4 business divisions within Graco. I think they've gotten more sophisticated since I left. It's been 9 years now. I know they still have quarterly review meetings, but I think that their attorney has not been drafting the application so much, and they have gone kind of more to having outside counsel draft those applications. And Graco, when I was there, had 1 IP attorney, and he had been with Graco for 32 years. So we never really did any search of technology or a prior art search for a particular invention disclosure. Doug kind of kept all that information in his brain because he had been there for so long, so he would know almost instantly whether this disclosure would have been redundant in light of a particular product that we'd already filed on. So, and regarding budgeting at Graco, I as the IP paralegal would handle the budgeting every year, but I believe they now have Serengeti, so they might be more sophisticated in terms of tracking their expenses and budgeting for filings and things like that.
So what you 4 have all described sounds like the normal process flow, assuming everything happens as it's supposed to. But I'm sure in each of your companies, things don't always happen the way they're supposed to. How did you deal with something like a bar date coming up that was during the process and would require a accelerated decision or something like that? How did you deal with exceptions to the process, particularly bar dates?
And we have a trigger set up in our system that if a bar date is identified, then an automatic email goes to one specific person to rush that along. So we are constantly using different docketed dates to auto-trigger those and make sure we're not missing them.
Okay. Mary, how about eBay?
We also have the auto trigger, but in addition to that, almost always it is an email from, an inventor saying, "Hey, I'm going to present at a conference tomorrow," or whatever it is that is the trigger. And at that point, they will talk directly with an eBay attorney, and then the eBay attorney will make the determination, and they'll turn it over to outside counsel. So it will bypass the regular review process, so that we can file a provisional application, at least get something on file, and then it will go back to the committee after the provisional has been filed.
Okay. Michelle, how about at Boston Scientific?
Yeah, I would have to say about the same thing. You always have some idea of when these dates are coming up, but inevitably someone ends up going to one of the attorneys and saying, by the way, I need an application tomorrow. So it happens quite often. We do go back and put those disclosures into our system and bypass the review board completely when that happens.
Okay. And Jennifer?
At Graco, our IP counsel, our attorney, would be a mandatory attendee at all product release meetings. So he would be more aware of something in that instance where a product is going to be released, but he would know then that he hadn't received a disclosure for 5 different things on that product release item, and so he would be made aware that way in a product release meeting. But there were the occasional times when, as an IP paralegal, I would be reviewing the product release material for a particular product going out the door, and I'd talk to my attorney and I'd say, "You were at the product release meeting, right? And you knew about this being released. Maybe you should call the engineers over at that division." So there were occasional times we'd catch it in that way, but most often the mechanism would be a product release meeting.
Okay. All right. My next question, we may have addressed this in the discussion we just had, but who manages the flow of information between those steps in the process, and who tracks what step, or maybe it's who or what manages the flow and who or what tracks the steps? If you've already talked about that in your comments, then another question I would ask is, what are the typical timelines for your internal processes? We heard eBay's 3 months is the target, but and Graco was on a quarterly timeline, at least with the disclosure meetings. But for Boeing and BSC, if you could also comment on the timelines, in addition to the who or how are you managing the flow?
So our flow at Boeing is managed by the system. We have reports set up to track each individual stage of the process, and we have a staff analyst that's running reports and providing that data in real time to management, basically, to make sure that things are moving. We also have a dashboard that comes up when you log into Memotech that you can see at a quick glance where things are in the process and how many days things are either stuck or what the overall landscape looks like. Our targets are, we try to look at a disclosure within 45 days of receipt of the disclosure in the system. Are we there? I would like to think we're close. Definitely not 90% as eBay is. But then after we do the review and we make the decision, our target for our outside counsel is to file it within 3 months. And again, we're not as good as eBay. We have probably about 65% are filed currently at that 3-month mark. But we do, after the 2-month mark, it starts to get our attention. So after that 2 months, we're starting to really work to make sure that things are moving along. But that's kind of our timing.
Okay. Mary, any further comments?
I'd like to add one thing that's been pretty helpful, effective for us. We require outside counsel to send us a weekly report of any applications that have gone past the 3-month date and why. So, you know, maybe the inventors are on vacation or on sabbatical or something, and in that case, you know, it's not outside counsel's fault. But generally, they don't want to be sending us that report, so that has been helpful.
Okay. Michelle, anything else to add or comments on timelines?
Well, I said before, the paralegals track it from submission receipt to when it gets sent to outside counsel. As far as the timeline, we try to get it to the board after submission within 30 days. We have boards normally once a month, so that usually isn't an issue. We do also file within 3 months, and we actually internally run metrics and present it to all of our internal attorneys to make sure that they know that they have applications that might be pushing up against that 3-month deadline, and we are in constant contact with our outside firms if they're running a little bit behind on the intermittent deadlines that we've set for drafts.
Okay. Jennifer, any further comments?
No, mainly it would be the IP paralegal managing all of the steps and, you know, reiterating and bringing up old disclosures at those quarterly meetings.
Okay. Well, we've spent a lot of time on the disclosure process, but that's such a big part of a lot of companies' IP programs. I do want to take a few minutes before we end and talk about Inventor award programs. In particular, in each of your organizations, how do you track Inventor awards? Who administers the program? And then, like, when and what type of awards do you give to your inventors? Angela, can you start us off?
Sure. So we track our awards program inside MemoTech again. We've set up a system for that. Who administers it? We have a staff analyst again, basically a former paralegal that handles that. We actually have also added a second person because we are processing so many awards. And then when? We have several different award programs. Our first award program is every inventor gets a pen for submitting a disclosure, and that's received once a year to make sure that, you know, every inventor, they go to conferences, they want their pen on them. The second program we have is we have what's called an award that's provided if we decide to defer or not file the disclosure, but it is of merit, meaning that there's, for whatever reason, we're going to keep it as a trade secret, or we decided we have enough in that technology, we're not going to go forward on it. Then an award, a monetary award, plus a desk trophy is provided to the inventor in that case. And then if we decide to actually file the application, a monetary award is provided at filing, and then once it's granted, the inventors get another monetary award plus a plaque. And then the third type of program we have is called a Special Invention Award. This happens annually, and what we do is we look at basically the best of inventions or best of the best that have come in that year, looking at the contributions they provided to the company, the amount of maybe revenue that is generated from that invention, or, you know, how many sales, was it something that really increased part of our aircraft? And those actually get recognized at a formal dinner event that you will have our CEO and our CTO there, and they also receive a large amount of money with another plaque type situation to say that they are part of that program. So those are just kind of a high level of our types of awards that we provide.
Okay. Mary, how about at eBay?
So at eBay, they get a very small award. They get a link in an email that takes them to a site where they can pick things like movie tickets or T-shirts or eBay gift cards when they submit an idea. At filing, there is an award for it's a cash award for the filing, and then also if it's a first filing, they get an eBay Inventor Club jacket, which they can choose. We have several different styles, but it has the eBay Inventor Club logo on it so that they're recognizable on campus. And at issuance, there is an award, a monetary award, as well as a puzzle piece that sits on their desk that has the the details of their patent, and also they get 8 hours of vacation time added to their vacation bank.
Oh,
and
cool.
That is all it's all administered by the paralegals, and that is an automated tool as well that integrates with our payroll system.
So it's not in Foundation IP, it's a separate internal tool that you're tracking with.
Correct. Yeah.
Okay. Michelle, can you tell us about Boston Scientific?
Sure. So our inventors receive a one-time award of $1,500 for either a provisional application filing, the filing of an original non-provisional application, or a PCT application that did not consist of the previous two. They also can receive a $750 award upon filing a continuation part. In addition to that, we used to give them nice plaques, the copper front plaques of the patent. We went now to a fancy folder with certificates of the granted patents, so they can kind of keep their portfolios in this folder. As far as tracking, we actually do use Foundation IP to track the awards, and that is administered by one of our paralegals.
Okay. Jennifer, tell us about Graco's program.
Well, Graco Awards gives patent awards one time a year, and it's upon grant of a U.S. patent. There's a big formal luncheon with the IP attorney and with our CEO and all of the inventors. When they get their first granted patent, they get a gold ring with a diamond in it, and so every successive patent that they have, they get another diamond added to their ring. So they receive another diamond in their ring. They also get a patent plaque with the front face of their patent on it, and also a silver dollar coin from 1926, which is when Graco incorporated. So as the IP paralegal, I'd be responsible for collecting up a bunch of gold rings from the inventors, and then also we worked with some outside vendors to track down the the silver dollar coins and put together the patent plaques.
It's interesting how creative companies can be when it comes to inventor awards programs, and they really do vary greatly from company to company, and there's some really clever ones out there. How do each of your companies deal with unique requirements from some foreign countries like Germany, where you have remuneration requirements and things like that? How do you manage those requirements in your systems? Angela, can you start?
Of course. So we have folks that are located in country. So in fact, in Germany, we do have a division there that helps us with those specific requirements. As well as we do have some of our dates docketed to make sure that we're following up internally to responding to those requirements.
Okay. Mary, anything?
Yeah, at eBay, when they submit their idea originally, there is a question that asks if they are a German or Chinese resident, which they have to fill out in order to submit. It requires them to fill out that field. And it also tracks where they are physically located. So the system is smart enough to know where they sit in the company. So we get both of those pieces of information. And if, for instance, it identifies a German inventor, it will kick off a series of docketing events in our Foundation IP that say, send this contract at this time, you must pay this amount at this time. So it's very specific requirements for each country that are automated depending on the idea submission itself.
Okay. Michelle.
We have inventors in Ireland and quite a few now in India, and the award systems are a whole lot different. I believe that the India awards are only paid out twice a year and at filing time.
Okay. Jennifer, did Graco have any inventors outside the U.S., or was this something you didn't have to worry about?
So when I was there, we have a European division, but they were mainly a sales force in Europe, responsible for selling Graco paint guns and other products over in European countries. So we didn't really have an issue with any of the European employees being named as inventors. And just as I was leaving 9 years ago, Graco had just been opening a manufacturing facility in Suzhou, China. So I would imagine they have something in place now for their Chinese employees, should they be submitting invention disclosures, but I'm not positive about that.
Okay. Well, and I'm going to jump ahead to one of the questions, because one of the questions that was submitted is somewhat related to these country-specific requirements. The question is, for Germany and Japan, if the company decides not to continue prosecuting an application, or perhaps maybe not even to file on a particular invention, the inventor can own and file it themselves. Do any of you in your companies have systems in place to transfer rights to the individual if the company is not interested in pursuing the invention?
I'll speak for eBay. Oh, go ahead. Sorry, Angela.
Oh, no, it's okay. Boeing does have something in place, Anne. We do have a process that they go through in order to request those rights. We keep that outside of our system while we're making that decision. And then once the decision is made, then we go ahead and we enter it into Memotech and start making sure our data is correct. We don't do that often, I will say, because our employees do sign an agreement that states that we'll own it, but we do in times because, yes, those laws, we are required for law to do that. But it's very hard to do.
Mary?
We do, especially in Germany, where even if they submit an idea and we don't move forward with it, we do pay them additional compensation as required under German law, and we have them specifically sign an agreement saying, in addition to their employment agreement, that they've submitted this idea and they are assigning the rights to eBay, whether we use it or not. So.
Okay. Michelle or Jennifer, anything further to add on that or not?
No, actually, we do it the same. So.
Graco didn't really have any specific provisions that I was aware of, but one of the clients I work with now, if they choose not to file on that invention disclosure, there's a mechanism that they use to have sign off and for the inventors to, kind of take back that invention and choose to file it themselves if they wish.
Okay. Well, just to summarize, really, I think every company is very unique in how they manage invention disclosures, harvest invention disclosures, and in particularly how they offer some type of incentive or award program. So today we've heard from 4 people on the invention disclosure programs in their companies, and 3 of those individuals come from companies with very large patent programs and a very high volume of disclosures annually. Hopefully for the members of our audience who are working in much smaller patent programs, you'll be able to take away some ideas for your own program as your own program grows and you have more of a need to have a more standardized, structured process to manage your disclosures internally. I'd like to take a few minutes and look at a few of the questions that we have that have been submitted. One of them is, can inventors see other people's invention disclosures in the system, or is access controlled? And how is access controlled if the idea is deemed a trade secret? Anybody want to take that question?
I will. So in Memotech, we have it set up that inventors only see their own invention, and it's done by name. It ties into their employee number, and that employee number limits then what they can see if their name is on that invention.
Okay.
And that's exactly how we do it at eBay. Yeah. They can see each other's patent applications once they're filed, but they cannot see invention disclosures.
Okay.
Yeah, Boston Scientific does it the same way.
And
Okay.
there would have been no capability for any of those Graco engineers to access the paperwork submitted by other engineers.
So it wasn't a problem.
No.
Okay, here's another question. How are companies handling multi-country inventorships? So multiple inventors on an invention disclosure from multiple countries. Any special processes in place when you have that scenario, or are they just treated the same as everything else?
I wish they were treated the same as everything else, but we know we can't, right? So we have specific country laws that we have to deal with. So, for example, if, in India, if we have a invention that has an Indian inventor as well as a U.S. inventor, we have to make sure we get a foreign filing license obtained for either first filing in the U.S. from getting the foreign filing license from India, or we have to get the foreign filing license from the U.S. to first file in India. So we do have a process for that, and we handle that in our workflow in the Invention Disclosure side of Memotech. It's not as easy or as seamless as we would like it, but we will not. There's a box that someone that's evaluating the disclosure has to, some boxes they have to check to make sure that they have looked at all these different issues, because a large portion of our portfolio has these joint inventorship issues.
Okay. Any other comments on that question?
I would echo everything Angela says, and we often wind up filing, in China first, or at maybe PCT application first, just based on inventorship.
Okay. Here's another question. How do you deal with awards for inventors who leave the company prior to the event that would trigger the payout or the distribution of the award? I mean, with the size companies you guys are in, I would assume that has to happen
at eBay.
Regularly.
It's very clear that they must be an employee at the time of the filing or issuance in order to receive the award. If they leave the company, they're no longer eligible.
At Boston Scientific, they must be an employee at the time of submission, but they also have to not argue with us when we ask for their signatures. If they aren't cooperative, then they don't get paid.
Okay.
And that's interesting, because Boeing takes a little different stance. You do not have to be an employee. You have to be an employee at the time of submission, yes, but throughout the process, if you leave the company, you still will get your filing awards, and those, unfortunately, are handled by my team as well. If they leave the company, we literally have to go get a W-9 for them and go and ask for a check request, because it's handled outside of the normal system. So we do still pay a lot of inventors. As you can imagine, we have 150,000 employees and a lot of turnover, so we're still making sure we pay them.
Okay.
People never leave Graco, so they are always there. They have a very they have a lot of longevity at that company.
Here's an interesting question, if you can comment on it, or if you even have this kind of statistic. What percentage of employees submit ideas or disclosures? Any idea? I mean, we know volume, right? But you guys are in very large companies, so I would tend to guess it's a fairly small percentage of the overall number of employees in an organization, but that's just a guess. Maybe that's not something you guys really track. You probably track just more of the disclosures that are coming in and the volume. Would that be correct?
Yeah.
And we do track it in at Boeing, but we track it by job classification. So of those 150,000 employees, what percentage are engineers versus, finance or other organizations that support the business. So we get a lot of our disclosures from engineering, some from IT, but engineering is the main base. And the percentage depends on the business unit that they're in. We definitely get more from our commercial side than we do from our defense side, which is something we continuously work on because our defense contracts do have that requirement if there is a developmental contract in order for the government to get certain rights to that invention. So it's a little nuanced probably than what other people don't deal with. But percentage-wise, on the commercial side, we're seeing about around 8%. And on the defense side, I would say it's about 3%.
Okay. Well, those are interesting numbers. Well, we've taken quite a bit of time. There's actually some more questions in the queue, but unfortunately we're getting low on time here. So I want to just take this opportunity to thank Angela, Mary, Michelle, and Jennifer for sharing your experience today, and then also to point out that we have another webinar coming up in this series. The next one in our new operations series is on best practices and processes for managing, drafting, and filing of U.S. applications. And I know a few of the questions that I didn't go into that were submitted had to do with who's doing the preparation of the applications and what percentage are done internally and versus externally. We'll get into some of that in this next webinar, which is on the 20th of November at 1 o'clock in the afternoon. So again, I want to thank everybody thank all of my panelists for participating today, and thank all of our audience members for joining this program, and hopefully you'll join for more of our operations webinars in the future. Thank you very much.